Today's guest is someone who's helped write the legal foundation for equality in this country. Ronalds AO SC is one of Australia's most respected barristers and a pioneer in discrimination law. She was instrumental in drafting the Sex Discrimination Act in the early 90s and has spent over 4 decades fighting for fairness in courtrooms, policy rooms, and across the legal profession. She's run landmark cases like Maloney v Queensland and the Palm Island class action, and helped establish the Indigenous Barristers Trust, a lasting legacy of support for First Nations lawyers. Chris has been recognised as an Officer of the Order of Australia for her service to the law and justice. But more than titles, it's her commitment to truth, equity, and mentorship that stands out. And beyond all that, she's been a massive mentor and friend to me. Chris, thank you for joining us. Let's have a yarn. Where does this podcast find you?
I'm on Ewan country, down the south coast, where I have a second house where I mainly live these days because it's so nice.
I can attest to that. We were fortunate enough, Liam and I, to come down and have lunch with you and Lindsay. I can understand why you spend so much time down there out of the hustle and bustle of up here in Sydney. Today, I was really excited to spend some time with you, and I think to set the scene a little bit, and the first interaction we ever had was somewhat humorous in the sense of I had come to the Indigenous Barristers Trust. I had found out about it from a friend who is our neighbour, and about a week after hearing about it, I was invited to an art auction at the DPP that the Indigenous Barristers Trust was throwing. And I show up, I don't know anyone, and you're sitting there at the reception desk taking people's names, and I had my ticket bought by me from one of the barristers, and that's all I kind of said to you. That was the only information I gave to you. And you said, what's your name? And I said, oh no, so-and-so's bought my ticket. And you just like sternly looked at me and just said, just tell me what your name is. Like, hurry up. And I just thought, I've annoyed this woman to her wit's end. And I walk off and I start, smoozing up with the judges and barristers that were in attendance. And then after you've clearly checked everyone in, you start wandering around, and then I get introduced to you. Oh, this is Chris Ronalds, and she's, appeared in the High Court, and she's done, she's drafted all these amazing anti-discrimination laws. And I just like, oh, if there was one person to not piss off, it would be Chris. But you sent me an article last week and titled Sex Discrimination Act, a Brief Drafting History. And you do start by saying that it's a story that you haven't told, but it does begin on a personal note around walking into Sydney Law School in 1969 as one of the very few women at law school. And so I think looking back now, what do you remember most vividly about that time and how it shaped you as a lawyer and an advocate?
I think it was a whole different world. I went straight from high school to law school. Most people did arts, but I came from a poor family and we couldn't afford the extra few years, so I just went straight to law school. So I'd been at a girls' school. My mum was a single mum by then, so I lived in a world of women, really, and I had 2 sisters and hadn't had anything to do with any blokes ever. And suddenly I was in an environment that was totally, absolutely male with a tiny little distinct. My year at law school, there were 10% women, and it was the first time there'd been that many, and there was just endless talk about how women were swamping the joint.
God forbid.
It made double digits. And it was then in the old law school, which of course has been knocked down and taken over and disappeared. But the old law school was in Phillip Street, opposite the Bar Association. And the common room opened onto the male toilet, and the door was always left open.
Right.
So you couldn't really go into what was supposed to be the common room if you didn't want to spend your entire time looking into the male toilet, which I had no interest in doing. Yeah. So the women used to use, there was an Ansett terminal next door where you'd got a bus out to the airport in those days. And so we used to have to use the women's toilet because there was only one women's toilet that was floors away in the law school. It was a bit of a startling environment. And then in our second year, the new law school opened, which is now gone, but it was also in Phillip Street. So we were not on the main campus ever. We didn't have anything much to do except for the Vietnam marches with the main campus, students on the main campus. So it was a very isolated, weird sort of life because we were university students slap bang in the middle of town, opposite then the only barristers' chambers in Sydney and the courts, directly on the courts. So it was a pretty weird place.
And on that, because a thought popped in my head around having law school quite close to the courts and barristers' chambers. Did you see value in that?
What used to happen was in third and fourth year, because law school was then 4 years long, in third and fourth year, people did what are called articles, and they worked in their third and fourth years in solicitors' offices. So it had to be close so that they could come and go from lectures. So lectures used to be at 8 and 9 in the morning, and then 4 and 5 in the afternoon in later years, so that you could go and do your work during the day. Because I was a girl with no connections, I never managed to get a job as an article clerk because no one wanted to take me. The first question I was routinely asked in all my interviews is, when are you going to get pregnant? When are you going to get married?
Yeah, yeah. And also, I know this story, but I'm guessing the jeans didn't help.
I didn't wear jeans to interviews, of course, but I was summoned to the dean's office. I really had no idea what the dean was.
Yeah.
When I was in second year, and I was lectured by this old white man with white hair, I didn't know who he was, that I shouldn't be wearing jeans at all to law school. Imagine, blue jeans. I shouldn't wear them to law school because we were in the middle of town and future employers would see me. And so I should be dressed all the time like I was going to work in a nice dress. Well, I didn't have a nice dress. That was a bit of a problem.
Yeah.
I'd get a couple of little skirts that I could wear. I don't think he thought mini skirts were the go, but I was told off for wearing blue jeans, which is sort of somewhat amazing now.
Yeah, definitely. Just out of interest, what was your favorite? We were just talking off air before this around I'm doing ethics and torts this semester, and you screwed your face up a little bit at torts. But what were some of your fond and favorite subjects that you did?
I didn't have many because it was a very commercial degree.
Right. Okay.
And the sort of subjects that are taught now in law school had never been heard of. Human rights law, discrimination law, all those sorts of things, of course, didn't exist at the time.
Yeah.
And New South Wales Uni opened in the early 70s, the law school. So when I went to Sydney Law School, it was the only law school in New South Wales. And New South Wales opened and it had a much better, wider curriculum than there was at New South Wales, but I'd finished by then.
Yeah, and it's interesting because even I think now and again, the friend that put me onto this Indigenous Barristers Trust is a lawyer. He went to Sydney Uni. And I think that there is still a bit of a stereotype of you go to Sydney Uni, it's the black letter law, it's very sort of strict and rigid in terms of the curriculum and the types of topics and sort of theories that you explore. Whereas UNSW, I would say to its strength, other people would argue that, you start sort of drowning out the purity of the law when you start thinking about, these theoretical ideas, or you start applying, feminist theory or, First Nations lenses on things. But I mean, it's kind of the practical nature of the law that it impacts people in different and diverse and unique ways. And so I think it's to the strength, but a lot of people still to this day think, oh, it's a bit of an airy-fairy degree. So, you can't win either way.
Well, certainly in the early 70s at Sydney Law School, it was corporations law, and that's what you did, and you learned it all, and that was all there was going on, basically.
Yeah. And so interesting that you somewhat, and I survived, it might not be the right word, but it's interesting that you kind of survived that indoctrination of becoming a corporate lawyer and sort of living in that world, but you've gone on to be instrumental. Has anyone ever called you the matriarch of anti-discrimination law? Like, I feel like you should be bestowed the title. If not, we'll bestow you right now on the podcast. You were instrumental in developing landmark legislations like the Sex Discrimination Act, 1984, the passage of Racial Discrimination Act, 1975, Anti-Discrimination Act for New South Wales in 1977, and the Disability Discrimination Act of 1992. You've written the book on, and you have written a book on it, a textbook. So has anyone ever sort of, donned any special title for all this amazing work you've done?
Well, no, I got an Order of Australia for sex.
Yeah. Okay, well, there you go. Yeah, that's good. That's pretty good.
And the Second Order of Australia for Indigenous work, but we'll leave that aside. I think that the major influence on my life, without a doubt, was Lionel Murphy when he was Attorney General. So I left Sydney and went to Canberra because I couldn't get articles because I was a working class girl. I went to ANU, had just started the legal workshop, so you did 6 months there, and then I stayed and joined the sparkling new Whitlam government, and Lionel Murphy was the attorney, and we started working. I ended up in the Human Rights Branch, which was brand spanking new, and there were like 3 of us. So I had the fortune to spend quite a lot of time with him, and he changed me forever, basically. He opened my eyes to other areas of law, and we were then working on the racial discrimination bill, and there was vociferous opposition, and my first job in the human rights branch of the Attorney General's Department was to answer all the letters coming in of people who hated the thought of a racial discrimination.
Right.
Second thing was to fight for the sexual harassers, which is where I learnt the meaning of the term, though I didn't know the term at the time because it didn't exist, of sexual harassment.
Yeah. And to pierce the veil, history repeats itself. And I think that, the referendum in 2023, there was a lot of vitriol spilled about what that would do and, people's lands being, hostile takeover of lands and property, et cetera, et cetera. What were some of the letters that you were getting around the Racial Discrimination Act and why it was such a bad idea?
Well, it was beyond many people's concepts that Aboriginal people should have any rights at all. It wasn't quite, there was also a lot of anti-migrant sentiment as well. Of course, they can't be treated the same as proper English-speaking whitefellas because they don't speak English and they don't speak it well enough, etc. But a lot of it was against Aboriginal people because in country towns, of course, in those days, separate bars in the local pub, well, you couldn't ever interfere with that. I mean, that was just how life ran. I mean, the thought that Aboriginal people might be in the same bar as a white fella, my God. So never mind get a job. Say no, you couldn't say no just because they're Aboriginal, but we've always done that.
It was
country town work.
Yeah. It was so interesting because I'm gonna get it up, but I when I was down, so the last few days I was down your way in Ulladulla and I stopped in at the Lady Denman in Huskisson and was going through the Maritime Museum, and I didn't realise this, but there was, under the Aborigines Protection Act of 1943 or something along the lines of that they gave certificates of exemption for Aboriginal people that basically assimilated enough to be exempt from a bunch of different legislations that around owning a bank account, owning land, buying alcohol, enjoying government benefits, but basically traded that off with, signing away their rights to tradition and culture and heritage. So, it's pretty crazy that you'd walk around with this kind of license of exemption.
And you had to have one if you wanted to live off the reserve and live in town, you had to have one.
Yeah.
Otherwise, you'd be picked up by the cops and taken back to the mission.
And I think people underestimate how, not that long ago this all was. I think people think that this was a completely different time when, in fact, it's less than a century ago, which is
I mean, even on Palm, which we'll get to, but on Palm Island, there was a street where the only Aboriginal people, this is an totally Aboriginal community, apart from workers, white collar workers. And the only Aboriginal people who were allowed to walk down the street were if you had a job in one of the houses on that street, because it was totally occupied by white people and no one else was allowed to walk down the street until the passage of the Racial Discrimination Act, when they were forced to stop that. It's just incredible.
You could imagine what type of jobs the black fellas had, working in the white homes.
Exactly.
And I think just taking a step back and sort of listing all of those legislations that you helped drive from, I feel like being able to look backwards and understand sort of the movement, would love to understand what you thought were the policy shifts and sort of the sense of why we were moving towards wanting and needing Sex Discrimination Act. Because I'm sure that there would be people who would argue that we still don't need it, but I think that it's now, common sense that we've got all of these anti-discrimination laws in place. But what were some of the lightning rods during that time in particular that really put it on the forefront that we needed some of these acts?
Well, it was the early days of the women's movement and feminism. I drafted for Senator Ryan, who was then in opposition, a private member's bill of a sex D bill that in the sort of late 70s, early 80s, that she then tabled in the Senate, but it was never voted on. And it was based loosely on the New South Wales Anti-Discrimination Act, because I was then working for the Anti-Discrimination Board. There were whole fights, which the Racial Discrimination Act had as well, about the use of the treaty power to international power to found Australian laws, and a lot of opposition by conservative lawyers, many of whom were in the Attorney General's Department, against such a wild thing. Of course, that was all brought to a sad end by the High Court for them when the Tassie Dams case said, yes, you could use it for environmental and heritage matters, and hence discrimination became acceptable despite all that opposition to both the RDA and the SDA.
Yeah.
So I guess I was naive. Well, I know I was naive. I wasn't very worldly. And I thought that if you changed the law, people would comply with it.
Yeah.
And people said to me at the time, well, people don't comply with the law of murder. Why do you think they'll comply with the law on sexual harassment?
Yeah.
And I guess I'm even surprised still this day that any bloke, for example, born who's under 40, sexual harassment has been unlawful since they were born, but
Yeah.
they're still doing it. So I was naive and thought that people would comply with the law.
Yeah.
And I think, I mean, there has been a radical change, of course. The sort of things
Yeah.
I put as a baby lawyer, the sexual, like, you know, a drunk, naked man leaping out of the cupboard in my office in the Attorney General's department and trying to rape me, that I doubt that happens much these days. But that was, you know, everyone went, oh, isn't he naughty? We'll take him home.
Yeah.
No one bothered to say, are you okay? Or do you need tomorrow off while you recover from that? No one ever bothered about that, of course.
Yeah.
No, we'll look after him. We'll take him home. He's just being a bit silly.
Yeah, it's just playing games. And
Yeah.
that was my next question. You said there has been a radical change. We also admit that this still happens. So, and I think that this may be a question that I had pegged for later, but where do you think that some of this legislation may be sort of outdated and not necessarily grown into a sort of modern technocratic society?
I think it's too bad in that regard. It's been updated over the years. The sexual harassment definition, for example, that I invented back then when was the first legislation in the world to use the term sexual harassment. And it was a new concept that two US feminists invented and wrote a book about. One of them wrote a book about it, and we just adopted it. Because I had plenty of lived experience from law school and AGs by then, so I didn't have any trouble with the concept. But I think what's disappointing is the enforcement and the pursuit of test cases, which happened more before, but they tend to get settled now because if you're looking particularly in the employment environment, particularly big employers are nervous about being on the front page of the paper, people who still read the paper or whatever, being accused of good old-fashioned sexism.
Yeah.
Now, we know that the wages still aren't equal, and we know that there's still sexual harassment, but nothing like there used to be.
Yeah.
But, you know, it's still not good. Don't misunderstand me.
Yeah, and is it a function of that we now have defined it, we can point at it, and that people are being better advocates of whether it be men or women calling it out or feeling more safe to call it out? Or is it, you know, I highly doubt it, but is it just a function that no one's doing it as much anymore?
I think there's not as much in a blatant way there used to be. But I think that the calling it out, the Me Too movement, those sort of changes have been pivotal in actually reducing. Now, unfortunately, I do not pretend that it has disappeared. But mechanisms for making complaints that are safer, still people aren't completely safe in some workplaces, in very male-dominated workplaces. You know, there's been recent reports about mines and things that show that things aren't good in very male-dominated workplaces still. But in others, I think that there's more recognition, and there's much more. I mean, there were no senior women. When I joined the New South Wales bureaucracy, I was 27 and the most senior professional woman in the whole of the New South Wales bureaucracy. Not because I was a genius or a star, I hasten to add. It's just that there was no one there.
Yeah.
That's just ridiculous.
Yeah. It's baffling because I think growing up now, we've seen the pendulum swing in terms of the data showing women are going to uni at a high rate. You know, there are still massive gaps in terms of remuneration for women, but yeah, it baffles me, some of the rhetoric coming out of, say, the United States, where, you know, men are putting a stake in the ground and saying, now it's gone too far and we're the oppressed, and, you know, women and, you know, diverse people and LGBTQI people and, you know, Native Americans, Aboriginal people, and, you know, they just now get everything and we're the oppressed. I think it's, it does baffle me, but
But if you've held power for a long time, you don't want to let it go.
well, and you know what? I was thinking about and I was thinking about this the other day. Given that we've done so much in terms of progressing the rights of a bunch of vulnerable groups of people, are we now technically the conservatives? Like, are we now trying to conserve the rights of us, and they're the progressives or the degressives?
I don't think so.
Yeah, no, I don't think so. But yeah, I thought that was a funny thing. Like, we're fighting to conserve our rights and liberties and freedoms against someone who wants to progress their agenda. But I think Pivoting slightly, want to talk about some of your big cases that you've had. In Watton v Queensland, you helped expose a pattern of racially discriminatory policing that went far beyond one death in custody, armed raids, ignored witnesses, and even an officer dining with the accused. Did you ever feel like the courtroom could deliver justice to a community that had already lost all its faith in the legal system?
I certainly did, and the hearing was split in two parts. So our part of the case was actually held on Palm Island in the hall because the community, as you know, burnt down the courthouse.
Yep.
Didn't mean to. It was burning down the police station next door, and the courthouse happened to catch fire by accident. But it had been rebuilt, but it was too small for us. There was too many of us. So we used the school hall where bells used to go off, which was exciting. And people came and sat in there a lot and watched a lot. So it was very open.
Yeah.
It's a very small community, so wherever, and we'd been there for weeks before. Joshua Kramer, who you might know, Aboriginal barrister in Queensland, and wandering around, people would talk to us all the time. So it was very much in the community. So, and anyone could come and sit in if they wanted to. They were discouraged from calling out, which happened a few times, especially after lunch. But it was an amazing experience to conduct the case actually on the island. One of the interesting things I did was we formed the view that it would be good for the judge to actually go to some of the houses, like Lex Watton's house, to see where. So if you have a description of 8 men in full gear with a gun pointing at you in your lounge room, if you're used to an ordinary middle-class lounge room, that mightn't be too bad. But these houses all are small houses, of course, because they're public housing. And so we took the judge to a number so she could properly see what 8 heavily armed men standing in a very small lounge room would do to the small children who were there and everyone else who was there. And that was a really important event when we were on 3 different buses so that we didn't pollute the judge, and drove her all around the community so she could see what it was like. It was pretty amazing. And then the second 2 weeks, we had a break, and then the second 2 weeks were in Townsville when they ran their case.
And so why was it allowed to be on Palm Island? Was it a cultural consideration from the judge? Like, how logistically, how do you get a change of venue?
Well, I'm told that it blew the federal court budget.
Right. Yeah, I could imagine that. Yeah.
So there's only one very small motel on Palm. So we were in that because we were representing the community. And there's only one pub. You can only drink in the pub. There's no alcohol anywhere else. And so the judge flew back and forth every day with the associate and the court staff back to town every day, which is a 20-minute plane trip. And so did the Crown. They went back and forth every day, and we stayed on Palm. We'd convinced the judge very early on, who's now, of course, Her Honour is now the Chief Justice, Justice Mortimer, that it was important that she'd be there and it'd be seen to be there and it'd be accessible to the community. Yeah. And she understood that.
And in terms of the legal question asked, could you just go into a bit more detail around what the legal question being raised on it?
Well, there's a definition of what's called direct discrimination, which is less favourable treatment on the ground of race in the same circumstances or circumstances that are not materially different, and it can be hypothetical. So we set up a hypothetical. If this had happened in the middle of Brisbane, would this have happened? No, because the police completely sealed off Palm and wouldn't let people on the island. You could get off on the Friday afternoon. So the teachers and the nurses and everything, the white fellas all left on the last ferries. But there were like kids from a school excursion who were on the mainland. They couldn't come home because they had no money. They were stuck in town. Fortunately, there's quite a lot of Palm Island people in town and they managed to sort it out. But so the planes couldn't fly in except when they were bringing the police in. So we contended that none of that would have happened if it had been in a suburb, even if it had been a percentage of Aboriginal people in the suburb of Brisbane. That was one of the main arguments, and Her Honour accepted that the peculiar circumstances of Palm Island being an Aboriginal community which was created by white fellas, there is a small natural community, but they're mainly created by people who were naughty. North Queensland were flown there 2 generations before. And so that was where the comparator was between what would happen on the mainland and the way the police treated them, the way the whole searches were conducted, the way people were arrested, what was said to them, all those sort of things showed quite clearly that this would only have happened in an Aboriginal community.
And what was the outcome of the case?
Quite significant financial damages for quite a big group of people. Anyone who was on the island on the day got some damages. If nothing had happened to you and you didn't have a exchange, you got up to $10,000, and then some people got over $200,000, depending on what the psychological damage they'd had with having guns pointed at them. And it was about 9 years after the event by the time we held the hearing. So there were some fantastic witnesses who were then 23, 24, 25 who'd had guns pointed at them by the cops when they were like 13 and 14. And they came, talked about it and gave this wonderful evidence. They were amazing. They gave the sort of evidence that you can really only dream of.
I'm guessing as
they were treated.
I'm guessing as an advocate, it's an easy day when you have people that have gone through something and they can, relive it vividly.
It was so fortunate in some ways there had been such a gap because they'd grown up by then.
Yeah, and they can articulate and sort of, understand some of the feelings and the thoughts around it. Was there any punitive damages?
Police force had to apologise, which they did. Caused me to fall off my chair. I mean, we tried to settle it repeatedly, including after our 2 weeks of evidence, we put in another settlement offer because there was a couple of months, thinking now they've seen what our evidence was on Palm, they must come sensible.
And did you get a feel for why they weren't settling? Did it feel like, they just wanted to dig their heels in?
Yeah, it was the Queensland government.
Yeah, of course.
I discovered accidentally that the other side referred to me as Little Miss SDG, and I had no idea what it meant. Nobody had any idea what it meant until someone finally told me I was Little Miss Southern Do-Gooder.
Right.
Because everybody knew the Queensland police were racist. So why would you come and run this huge case with silks and everything running around? I mean, it was self-evident.
Yeah.
But that was a disparaging way in which they never spoke to me, and that's how they referred to me.
Speechless. I mean, given the Sex Discrimination Act, you'd almost have a claim there after that. Moving on to another case of yours, Maloney v Queensland. Queensland's busy. Let's just put it that way. You stood before the High Court arguing that a law that disproportionately criminalised Aboriginal people was not just ineffective but unjust. The court upheld it as a special measure. Looking back now, was that decision a legal failure, a moral one, or both? And what does it say about how far the law will bend to accommodate injustice when it's cloaked in good intentions?
Well, I have to disagree with your fundamental assertion. While we lost the case in the High Court, we won the bigger argument.
Yep.
We managed to redirect the policy choices by saying that there has to be free and full consent from the community, which had never been taken properly into account, and which the High Court, to their shame, never did. And that's where they mucked it up. But they accepted a lot of our arguments. So Tony McAvoy, who wasn't Silk when we did it, he and I did this case, and it was a remarkable experience. But a special measure is when is designed to provide opportunities to eliminate racism and go further and provide an advantage to overcome history of racism, etc. So all the programs that the New South Wales Bar Association runs for Aboriginal students and Aboriginal lawyers, they are all special measures on the whole. The Indigenous Barristers Trust is a special measure because we provide special benefits for people who would otherwise not have access to such benefits, i.e. money, but only for Aboriginal people because they are disadvantaged. So it was said to be a special measure because it was needed because of the rate of alcoholism and violence in the Aboriginal communities, and so the only way to do it was for white fellas to tell them what to do.
And so, the special measure applied was the banning of alcohol consumption, or was it also the purchase? Was it everything?
Yeah, on Palm you can't have alcohol. I think they varied it now, but like when we were on Palm, you could only have 2 glasses of wine in the pub a day, and you can't have any alcohol in your house.
Right, okay. And so it was deemed a special measure of basically protecting Aboriginal people because obviously, they get too drunk and then, can't function at a high level using it, and so we'll ban it, and that's a special measure and for the good of the community.
That's right. So they can't be trusted to look after themselves, so we've got to do it as nice white fellas.
Yeah, and so the court did uphold that it was a special measure and basically, found that it was for the betterment.
Yeah, it did. But as I say, the general principles that we were trying to establish, we established. So we don't see it as a total loss. We see it as an 80% win. Just because we're naive, you might say.
I'm maybe a bit confused on what principle was established, because I think as a law student, we're always told to look at the ratio and, if there's a dissenting judge, it's influential, especially at the High Court. It's influential, but it's not binding on precedent. And so what principle did you set up but ultimately sort of lost the case based on the fact that it was still deemed as a special measure?
What's happened since is the important other components of the arguments which were accepted was that there must be consultation with the community itself before you impose such things. So that was what hadn't happened before. Now, the content of the community consultations in some instances might be arguable, but as a principle, that was.
I was about to say the voice to parliament. It sounds pretty familiar, but yeah. And so actually, I guess on the technicality of that, was the banning or the prohibition of alcohol, was it an executive decision or was it legislated?
It was an executive decision, and then there was some legislation to back it up.
Okay.
And that's happened since. Yeah.
Right, okay, that makes sense. Looking at the legal hierarchy, the High Court is by far the most symbolic pinnacle of the profession. We're often learning in law school about High Court rulings, that sets the most senior precedent in our common law system. And I don't know if this case was the first time you appeared in it, but what was it like appearing in the High Court? Were you nervous? Were you excited?
I have appeared in the High Court a few times, but I wouldn't pretend that unlike some of my colleagues who have a basically solely High Court practice, that's not me. I haven't been there for years. Maloney was the first time I appeared for the main party as a silk, which meant that I was mainly on my hind legs, not as the junior counsel. And it was very nerve-wracking. The High Court has gender-divided robing rooms, so that was quite good because I was the only woman, so I could sit quietly by myself before we went in. And then as I stood up, one of the judges, I don't know if you've been in the High Court, but there's windows on one side of where the judges sit. You can look out the window. One of the judges pushed his chair back and looked out the window and didn't listen to a word I was saying, which was somewhat disconcerting, I have to say, but I ploughed on. McAvoy sitting next to me just muttered, "Keep going."
Yeah. He wasn't writing any judgments. He would have just concurred with one of the other judges and go, "Oh, that sounds about right. I'll just say that I agree."
He clearly made up his mind before we started.
Yeah.
Rude.
Yeah. Moving on from some of your cases, I think, and kind of the reason why we're here today is that you've spent a lot of time supporting and mentoring Indigenous lawyers, women, young barristers. And I think that that'll be one of your biggest legacies. The Indigenous Barristers Trust, you helped establish it in 2001 with the New South Wales Bar Association. What led you to that? What was happening that you thought that this was a necessary endeavour?
I'd been at the bar for a while, and it concerned me that there were so few Aboriginal barristers. And so I started to think creatively about what was the problem. And what happened was that in those days, most Aboriginal lawyers who finished law school went to work either for Legal Aid or the ALS, or more commonly went into the bureaucracy where they had a safe job with a good, secure salary and a good salary for what their families had come from. And they stayed there and never came out. And if I talked to any of them, it was because they didn't have the money to come to the bar. So I thought about that a lot, and then I decided we should set up a trust. I didn't realise what I was taking on. Yeah. Philip Self was then effectively the CEO of the Bar Association, and he was a friend of mine, and he and I talked a lot about how we could do it. We decided on the trust. We set up the trust. We applied to the tax ATO for tax exempt status. They knocked us back. We appealed that decision, and the ATO was completely horrified. They didn't seem to understand what we did, which was going to the federal court we did every day, so it wasn't a problem. Thanks very much. Yeah. And so we got a few barristers who acted for free on our side. There was a lot of support. And at one stage, 1 week before we had the hearing, the silk appearing for us said, "You do actually have some money in a bank account, don't you? Because, we need a separate bank account." And I went, "No, because we were waiting to sort all this out. We haven't opened a bank account." So we had 5 days. So 2 of us hit up the bar and we got $50,000 in 4 days. So then the silk was able to stand up and say to the judge, "Yes, we do have a bank account." Fortunately, nobody asked how old it was. And yes, it does have $50,000 in it, given by barristers who don't even know whether they're going to get a tax deduction. So that was how we started. We then won the case. The ATO was even crosser, and they then appealed. Helen Coonan, who was a member of the Bar Association and then Assistant Treasurer in the Liberal government, and we negotiated the deal. So we changed 2 words in the trust deed and moved 1 comma so that they could say the trust deed was amended and isn't the same as the one the court ruled on. And we proceeded, and that trust deed has been used by doctors, pharmacists, and other bar associations in other states. It's become the sort of model for this sort of charity. So we had fun along the way.
It's ironic that they decided to challenge a trust that was set up by barristers, probably a bit short-sighted there from the ATO. Given that you've helped so many people with the trust, what have been some of your favourite success stories of people that have come through? Other than me and my podcast, world-renowned, award-winning podcast that you're now on.
Well, apart from that, it's just been exciting to see kids when they first come, and when they're first coming to law school. We participate in the University of New South Wales special program they have for kids coming to law school, and they come to the Bar Association for the first time. Some of them have never been in the city before because they come from country New South Wales or elsewhere. And we help law students who run into deep financial problems. So we've managed to, like, one young woman was in her very last semester of her last year, and her family split up and she couldn't stay in Sydney anymore. So the trust funded her to go to women's college and have somewhere safe and secure to live for her last semester, which she wouldn't have had otherwise. And we've helped people in all lots of ways. But basically our major function is to support First Nations barristers for the first 5 years, if that's how long they need it when they come to the bar. So we fund all the exams and books and bar course and all that sort of stuff, chambers fees and things, so that people have a financial basis to proceed with.
And just on that point, I think it's become a thorn in the side of Chief Justice Bell at the New South Wales Supreme Court around kind of all these different hurdles you have to jump through to end up being. And, I think for any law student, it is somewhat of a pain and it's a cumbersome process that you have to go through to become not only just a barrister, but just a solicitor. But that is compounded for groups of people that are more disadvantaged and vulnerable. Is there any thoughts on what should be like, what the future state of admittance is?
Well, I oppose any exemption and not meeting the same standards, because I think that will haunt people for the rest of their lives. So, don't make First Nations people do the bar exam. No, I don't agree with that at all. What we do, as we have set up a special program to help work with people before they sit the bar exam so they can pass it.
And elevate them to a position where they can put their best foot forward.
Yeah, rather than suggest that they don't do it, because I don't think that's fair on them for the rest of their career. And same as we have funded many students to go through PLT, Practical Legal Training Course, at the College of Law, I don't think that we should have to do that.
Yeah.
And they supposedly set up a program, but I don't think anyone's ever had access to it because they never told anyone about it. So I'm with the Chief Justice. I think that all needs to be looked at.
Well, as someone still going through the process, if it can be done by the time I'm finished, which at this rate, it could be in 3 years or it could be in 13 years. So I think just kind of wrapping up here, but thinking about and looking towards the future. And I think for First Nations law students, you've mentioned a few, prominent First Nations profiles in the legal world. Tony McElvoy being in Silk.
He was the first First Nation Silk.
Yeah. So a bunch of people that have kind of laid the path forward, and we look across to things like the referendum, which failed. Where do you see the future for First Nations lawyers?
There are many more opportunities now with special employment programs with the big law firms and things than there were 20 years ago. And that will gradually make a difference to people getting opportunities. And there are more First Nations lawyers now who've got 10 years behind them, which 20 years ago there weren't. So the profile is changing. It's slowly, but we've got a small numbers base, so that it'll always be small numbers. But we've got more. That's no doubt about that. One of the good things that the New South Wales Bar Association has done is run a mentoring program for many years now. And that came out of, we held a one-day workshop for First Nations law students back in 2008, and they'd never been together from other universities. This was a first. We asked them what they wanted, and they said they wanted a mentoring scheme. I said a mentoring scheme with individual students, with individual barristers, and that has been a huge success. And many of them are still friends, still rely on each other, and sometimes I think the barristers get more out of it than the student. But anyway.
And a lot of the time, mentoring relationships aren't a one-way street.
That's right. And a good mentoring relationship should be one.
Yeah, exactly right. And I'd say that I'm now a beneficiary of the mentoring program. I was partnered with Hannah Robinson, who is quite junior, recently went to the bar. She's now at 11 St. James Chambers. And so, yeah, I meet with her quite often, and she's been like a tremendous help in sort of framing some of my thoughts about whether I make a move away from commercial work into legal work, whether I go full time into my law degree. Afterwards, do I join the bar straight out of uni? I'm sure you've got your own position on that, or whether I go off and do some litigation work. So yeah, it's been a great utility for me.
That's good.
So to wrap up, I ask the same question to everybody, but if you could see a certain guest on the podcast, who would you recommend?
Can I cheat and have two?
Yes, of course you can.
So I would suggest Marinda Dutton, who works for the Legal Aid up on the North Coast and has been a major program leader. She was at the 2011, it was her suggestion we needed a mentoring program, but she is a wonderful leader, First Nation leader in the ALS environment, and has done huge amounts. And the second would be Malia Ben, who you probably don't know, who's an Aboriginal barrister in Cairns, who has been working on some of the big class actions that I'm working on. So she's working on big discrimination class actions, and she's cutting her way at the bar in a very interesting way.
Awesome. I'm going to have to try and chase them down. If you could introduce me, that would be a massive benefit for me. Otherwise, it'll just be this random guy cold emailing them or cold messaging them on LinkedIn saying, oh, well, Chris Ronalds suggested you. So
I know. I'll set it up.
Awesome.
I might do it till tomorrow, but I'll do it.
That's fine. No rush. Okay. Well, that's it. I think, thank you so much for spending the hour. Yeah, I think it's done. I'm looking at Liam and he's got a massive smirk on his face. Here, let me turn him up so he can talk and say hello.
Hi. I'm sorry you can't see me. I guess, did Harry actually ask you about what you see as the next big change within law? Like, you've had tenure within this field for so long. We've seen changes in the rights of women, the rights of Indigenous people. But what do you think will be sort of the next thing that will be incorporated into the changes we see within society and law?
I don't know, really. I think that race discrimination will continue to be contentious in this country for a long time. And I think that I hope as your generation becomes more powerful, then that will fade. That's my hope.
And yeah, actually going on that, obviously you said that that's your hope. And I guess what is your greatest hope to see in the future for law?
I'd like to see effective enforcement of the discrimination laws so that it works properly across the country and is done publicly and be accountable and transparent, have transparency and not get buried in NDAs.
You know what, again, just thinking about it and sort of what's playing out in America is that it is the whole legal system and the three arms of government, the executive, the judiciary and the legislative. It is a bit of a house of cards. You've got, Donald Trump and the executive completely disregarding judicial rulings and orders, but it's kind of interesting just how they all interplay. We've got the Racial Discrimination Act, for example. The executive then has to enforce that. Or do you think that there needs to be more work done at an executive level to kind of frame up how we tackle some of these things? Legislation's just one part of it. What role do the other two arms have to play? Can the executive be doing more?
I think that the creation of opportunities for people to pursue litigation, because I think sometimes people underestimate the power of litigation and how one case can flow on to other places, like as happened with Palm. Palm really breathed life into the Racial Discrimination Act that had been lost from it. It was the first case, a big class action, for example, on the RDA, and I think that people suddenly looked at it differently. And if you've got the capacity to run those sort of test cases, which means that you've got to have legal aid and legal resources available to people who need them, so that the capacity to run cases properly. And at the moment, most of the big RDA class actions are being funded by litigation funders, which is the way they run now, and that may or may not cause people to be happy or not. The thing is to be able to have access to information, because they're technical decisions that what sort of evidence, etc., that can be made by your legal support. That's not what the punter has to do. The punter has to know that there is information and resources available and avenues available.
I think sometimes it's crazy to me, and I've had conversations with, say, my mum about this high-functioning autistic young man, and he's doing an apprenticeship as a panel beater, but the panel beater doesn't pay him. It's like some people don't even know that there are avenues, recourse that they can take to support the right just to be paid for one's work and things like that. So it's not even the accessibility to the law, it's kind of the accessibility to just understanding what's wrong and right. Yeah. And it's kind of this another interesting thing that, and it's straight out of the law school sort of textbook, is this idea of we're just got so much legislation that, it's so hard as a populace to keep up with sort of everything and whether or not there is recourse for this or it's against the law to do that. But yeah, that story baffled me. It was like, well, if you need any help, I know a few people that I'm sure would be willing to have a chat with the young man about what he should be doing.
That's right. Well, the Disability Rights Centre would be
the
specialist law centre just for that.
Thanks for tuning in to this episode of YARNS with Chris Ronalds. Her legacy as a champion for justice and equality speaks for itself. If today's yarn sparked something in you, share it with someone. Until next time, this has been Harry Stewart. Yarn to you later.